An Article 5 convention, can it be limited? This process for altering the Constitution has been debated for years. Article 5 states that when 2/3 of state legislatures submit their applications to Congress, Congress shall call a convention. Promoters of a convention claim it would be limited to the specific state application for a convention. Promoters of a convention think it would work like this. Congress receives the same application from 34 states. Delegates from the 34 states would have their commissions or instructions from their state legislatures. Following their commissions, they would only debate and vote on the amendment or amendments mentioned in their applications. This sounds straightforward enough. However, there are many problems with this theory. For instance, where would the other 16 states fit into this process? Since those states did not submit an application, they would likely not impose the same limits on their delegates as the 34 states would. Convention promoters also claim the ratification fail-safe safety net would prevent any bad amendments from being approved. Ratification of any amendment needs the approval of both houses in 38 states. Promoters believe, with this process, there is no way a convention could exceed these boundaries and become a runaway convention. However, that is exactly what happened in 1787. Back then, the convention was also called as a limited convention to make changes to the Articles of Confederation. The convention began with commissions from 9 of the 13 states binding their delegates to the ratification process outlined in the Articles of Confederation. Months passed while many drafts and revisions were debated and voted on. What was intended to be just changes became much more. Per the Articles of Confederation, the ratification process required unanimous approval by all 13 state legislatures and Congress. This meant that just one state could block a revised constitution. However, with their new constitution, the convention changed the ratification process so that it would take 5 states to block the ratification. As history from 1787 has proven, even though there were strict limits on their power, those limits were ignored by the delegates. The convention transformed itself into a convention of unlimited power, otherwise known as a runaway convention. Madison conceded in Federalist 40. In one particular, it is admitted that the convention have departed from the tenor of their commission. Instead of reporting a plan requiring the confirmation of the legislatures of all the states, they have reported a plan which is to be confirmed by the people and may be carried into effect by 9 states only. Many would think the commission should have been sufficient to force them to uphold the original ratification process, but they weren't. Yet just because the original ratification process was not upheld does not mean the Constitution was illegally adopted. In Federalist 40, Madison suggests they acted upon the transcendent and precious right of the people to abolish or alter their governments, as to them shall seem most likely to affect their safety and happiness. The Declaration of Independence declares this power of the people is a higher authority than the power of the states, Congress, or the Constitution itself. It was this power of the people which created the states, then through the states created the Congress and the Constitution. So, by appealing to the higher power of the sovereign people, the Constitution was legally adopted. This is a perfect example of how a modern-day constitutional convention could use this higher power to change the ratification procedure even further. So thinking back to the promoters' fail-safe ratification procedure, is it really safe? Let's take a lesson from history. At the time, the problem at hand was the Articles of Confederation and its many flaws. That is why the convention was called. When looking at our present Constitution, is the actual Constitution flawed, or is it just not being followed? Calling a convention will not fix the problems we are witnessing today. The real answer is constitutional enforcement. When the people understand the Constitution and demand adherence to it, Politicians will either follow the Constitution or be removed from office. The natural effect of enforcing the Constitution will be less government, more individual responsibility, and with God's help, a better world.